I think we'll all agree that Lady Justice Carr is a very inspiring figure, and very so much to me, and also probably responsible for the reason I'm at the bar, because I completed my very first mini pupillage with Sue a few years ago, and probably more than we would like to say. I'm very grateful that you've agreed to speak for us this evening, not least because I'm conscious that TECBAR owe you a dinner to congratulate you on your appointment to the Court of Appeal. We hopefully will be able to put that right soon. So on that note, I'll hand over to you and look forward to hearing what you've got to tell us about Halliburton.
Well, thank you, Rachel, for the warm welcome. It's very nice to be with you all. When I chose the title of Small Worlds, I had hoped that our physical worlds would still not feel quite as small as they still do. I would very much have liked to see you all in person, but we are where we are. All of you are engaged, if not daily, then very frequently in arbitral dispute resolution. The global arbitral industry is huge, but in certain fields, at least, it can involve only a relatively small number of appropriately qualified arbitrators and experts, and indeed advocates, something that is, of course, welcome news for TECBAR. It can be a small world. As parties' enthusiasm for arbitration grows and specialisation increases, the question is begged, was it always inevitable that we would start to see conflict issues arising out of arbitrations coming before the courts? The English courts are rightly keen to respect party autonomy and parties' decisions to enter into arbitration agreements. That means, amongst other things, upholding the integrity and privacy of the resulting arbitral proceedings. The courts, as you know, are slow to interfere with arbitral decisions, consistent with the underlying principles of the 1996 Arbitration Act. But the issues which arise out of the two recent cases I'm going to talk about concern not so much the substantive decision-making within arbitrations, but rather the process of setting up what one might call the personnel, the arbitrators and the experts. That process, as you know, can be a complex one. It can give rise to sensitive and troubling conflict problems, as the facts of Halliburton and Chubb, the one involving arbitrators, and Secretariat Consulting and A Company involving experts demonstrate. The facts of those cases have given rise to the need for judicial intervention, and in the case of Secretariat, on an urgent basis. I'm going to talk first a little bit about Halliburton. The story there began long before the initial bias challenge. Halliburton and Chubb commenced a Bermuda form arbitration in January 2015, in which Halliburton made a claim in respect of its liability insurance policy. The claim, as you know, arose out of the Deepwater Horizon drilling disaster in the Mexican Gulf in 2010. By the way, lockdown breaking news. I've just watched the film for the third time on Amazon. Mark Wahlberg is absolutely brilliant, magnificent. Anyway, tragic damage caused by an explosion and fire on the rig, giving rise to several arbitrations between insurers and insured. Halliburton claimed against Chubb under the policy. Chubb refused to pay the claim, contending, amongst other things, that Halliburton's settlement wasn't reasonable and or that Chubb had acted reasonably in not consenting to it. As you know, the Bermuda form is a standard form policy. It's been in use for the last 30 years or so. Not only are there a relatively small number of insurers frequently involved in disputes under it, but these insurers often instruct the same solicitors and counsel, and they choose their arbitrators with their clients from a relatively limited pool of retired judges or silks, well known to insurers and their lawyers. Now, Halliburton had the standard arbitration clause providing that the tribunal was to consist of 3 arbitrators, 1 appointed by each party, and the third by the 2 arbitrators so chosen. In the event of disagreement between the arbitrators, then appointment was to be made by the High Court. In Halliburton, there was no such agreement, so an application was made to the High Court under Section 18. Mr. Justice Flo, as he then was, and as you all know, appointed Ken Rokerson, Queen's Counsel. Before Ken Rokerson expressed his willingness to be appointed, he disclosed to Halliburton and the court that he had previously acted as an arbitrator in several arbitrations in which Chubb was a party, including as a party-appointed arbitrator nominated by Chubb. He also disclosed that he was currently appointed as arbitrator in 2 pending references in which Chubb was involved. None of that deterred Mr. Justice Flo, as he then was, from considering that it was inappropriate to appoint Ken. There was no impediment to appointing him, and that is what the judge did in reference 1. In December 2015, the arbitrator accepted appointment as an arbitrator by Chubb in relation to an excess liability claim brought by Transocean, but arising out of the same incident. Let's call that reference 2. In August 2016, he accepted appointment in another arbitration arising out of the Deepwater Horizon incident, this time as a substitute arbitrator on the joint nomination of the parties, in a claim made by Transocean against a different insurer on the same layer of insurance as the claim in reference 2. So there are 3 points, I think, to pick up on at this stage. First, the appointment by Mr. Justice Flo of Rokerson as the 3rd arbitrator is seen by many as the beginnings of the end of this story. It is a decision that couldn't be challenged, and it didn't require to be reasoned. And the problem, perhaps, was that Rokerson had always been Chubb's preferred choice. Secondly, before accepting appointment by Chubb in reference 2, the arbitrator disclosed to Transocean his appointment in reference 1, and in the other Chubb arbitrations which he had disclosed to Halliburton. Transocean didn't object, but the central omission, of course, to the disclosure issue that became before the Supreme Court was that he did not disclose to Halliburton his proposed appointment by Chubb in reference 2. Thirdly, note that the Transocean reference gave rise to a point of policy construction that didn't arise in the Halliburton arbitration. That policy point was amenable to be decided as a preliminary issue. Now, the arbitrator didn't know about this issue when he first accepted his appointment to sit in the Transocean reference, but it was known by the time of Halliburton's challenge in the High Court. Now, the preliminary issues that had by then been ordered but not determined arose on an issue that, if decided in Chubb's failure, might solve Rokerson's problems altogether with Halliburton, because it would remove the Transocean reference entirely, avoiding the need for the arbitrator to delve into the facts of that reference. And this was a factor that weighed heavily in the mind of the Supreme Court when they ultimately came to the conclusion that there was no apparent bias and no need to remove Rokerson as arbitrator. Tracing the history of the litigation through, Mr. Justice Popplewell, as he then was, had to deal with it at first instance. He delivered what can only be described as a logical and internally consistent judgment. He found nothing objectionable about an arbitrator accepting multiple appointments in arbitrations with overlapping subject matter involving one common party. Halliburton had relied on 3 elements of the arbitrator's conduct as giving rise to an appearance of bias. First, his acceptance of the appointments in the Transocean arbitrations. Secondly, his failure to disclose those appointments to Halliburton. And finally, his response to the challenge on his impartiality. As to the first, Popplewell J. found that Rokerson had been entitled to accept multiple appointments in circumstances where there was one party common to both appointments. Neither the remuneration that he would earn from the arbitration, nor the information that he would glean from it, would cause a fair-minded or informed observer to have any doubts about his impartiality, said Popplewell. He emphasised the arbitrator's duty to act independently and impartially, enshrined in Section 33 of the Act. The judge also found no difficulty in reaching the same conclusion, no matter what the degree of overlap in the subject matter of the arbitrations. And here, perhaps, it is where we see the recognition that the world of arbitration can be a small one. Popplewell J. highlighted that it is a regular feature of international arbitration in London that the same underlying subject matter gives rise to more than one claim and more than one arbitration without identity of parties. Not only is it common for those with relevant experience as arbitrators to sit in different arbitrations arising out of the same subject matter, the judge considered it to be desirable. One of the reasons why arbitration is chosen as the preferred form of dispute resolution is precisely because the parties want their tribunal to have particular knowledge and expertise in the law and practices of the business and markets in which the parties operate. The judge said this: arbitrators with such knowledge and expertise, who command the confidence of the parties, often comprise a limited pool of talent. It is undesirable that parties should be unnecessarily constrained in their ability to draw on this pool if there are multiple arbitrations arising out of a single event or overlapping circumstances. One can detect the concern for imposing harsh rules on arbitrators, given its potentially negative effects on them and parties alike in being able to choose a suitable arbitrator in a given arbitration. As to the second element, Popplewell J. found that the arbitrator's failure to disclose his appointments to Halliburton were not in breach of any requirement to disclose. The arbitrator was not required to make disclosure of those appointments. That was the consequence from his conclusion on the first question, namely, that simply because the arbitrators had the other appointments, they did not of themselves give rise to any justifiable concerns over his independence. Ex hypothesi, the arbitrator was under no obligation to disclose them. Popplewell J. further held that even if the disclosure was something which ought to have been given, the failure to do so did not give rise to a real possibility of apparent bias against Halliburton. The arbitrator's explanation in correspondence was that he hadn't done so because it hadn't occurred to him that he was required to do so. So, said the judge, even if that honest belief were mistaken, the fair-minded observer wouldn't think that there was a real possibility of apparent bias. As to the third element, the judge went through each of the complaints about the arbitrator's response to the challenge to his impartiality and rejected them. He said the arbitrator had dealt with the challenge in a courteous, temperate and fair way, demonstrating commendable even-handedness. There were therefore, in his view, no justifiable grounds for removing the arbitrator. As you know, the matter went up to the Court of Appeal, which dismissed the appeal, upholding the decision, but on different grounds. The court accepted that inside information and knowledge may be a legitimate concern for the parties to have in overlapping arbitrations involving a common arbitrator, but only one common party. But they found at the end of the day, this did not justify here an inference of apparent bias. But the court did find that arbitrators have a legal duty to disclose facts or circumstances which would or might provide the basis for a reasonable apprehension of lack of impartiality. The court highlighted that the test was an objective one to be judged by reference to what the fair-minded and informed observer would or might conclude. However, having concluded that there was a legal duty of disclosure on the arbitrator in this case, which had been breached, the court declined to hold that anything flowed from the breach. It considered that a number of factors indicated that the fair-minded and informed observer would not conclude that there was a real possibility that the arbitrator was biased. And so Copperwell J had been right not to remove him. In particular, 1, the non-disclosed circumstance did not in itself justify an inference of apparent bias. Secondly, the disclosure ought to have been made, but the omission was accidental rather than deliberate. Thirdly, the very limited degree of overlap meant that this was not a case where overlapping issues gave rise to any significant concerns. Fourthly, the fair-minded and informed observer would not consider that mere oversight in such circumstances would give rise to justifiable doubts as to impartiality. Fifthly, there was no substance in Halliburton's criticisms of the arbitrator's conduct after the non-disclosure was challenged. The Supreme Court agreed with the Court of Appeal that the arbitrator was under a legal duty to disclose relevant matters. It was not a question simply of good arbitral practice. An arbitrator is under the statutory duties in Section 33 to act fairly and impartially in conducting arbitral proceedings, in decisions on matters of procedure and evidence, and in the exercise of all powers conferred on him or her. Those statutory duties that give rise to an implied term in the contract between the arbitrator and the parties that he or she will so act. It is an essential corollary of the statutory obligation of impartiality. In doing so, the decision of the Supreme Court is, I think, to be welcomed. It promotes transparency in arbitration and aligns UK practice with international standards of best practice, as seen in the IBA guidelines and in the requirements of institutional arbitrations, such as those of the ICC and the LCIA, as evidenced by the intervention of the ICC, LCIA and CRAIB in Halliburton. All of them argued in favour of the recognition of such a legal duty. The Supreme Court went further than the Court of Appeal and confirmed what the Court of Appeal didn't. Firstly, that the acceptance of multiple appointments concerning the same or overlapping subject matter with only one common party may be sufficient in and of itself to give rise to the appearance of bias, depending on the relevant custom and practice. Secondly, in cases in which disclosure is called for, the failure to do so might, in and of itself, give rise to the appearance of bias. The Supreme Court agreed with the Court of Appeal critically in terms of outcome. The time for assessing the possibility of bias is the date of the hearing of the application to remove. And the Supreme Court also accepted the Court of Appeal's formulation of the duty of disclosure, namely, disclosure should be given of facts and circumstances known to the arbitrator, which in the language of Section 24 of the Act would or might give rise to justifiable doubts as to his or her impartiality. But note that the Supreme Court added the qualification, per Lord Hodge, who did not rule out the possibility of circumstances arising in which the duty of disclosure would extend to a duty to make reasonable inquiries in order to discharge it. Contrast that with the Court of Appeal, which said that there would be no duty of inquiry. Applying those principles to the facts of the case, the arbitrator was under a legal duty to disclose his appointment in the reference to Halliburton. Those were circumstances which might reasonably give rise to the real possibility of bias. So the arbitrator had breached his legal duty. But the court went on, as you know, to determine that the fair-minded and informed observer would not have inferred from the oversight that there was a real possibility of unconscious bias. The main reasons were, firstly, there appears to have been a lack of clarity in English case law as to whether there was a legal duty of disclosure and whether disclosure was needed. Well, of course, that's not going to be a reason that comes into play in the future. Secondly, the time sequence of the three references might have explained why the arbitrator had seen the need to disclose reference 1 to Transocean, but had not identified the need to tell Halliburton about the second reference. Thirdly, the arbitrator's measured response to the robust challenge disclosed that it was likely that references 2 and 3 would be resolved by the preliminary issue, and so that there would not be any overlap in the evidence or legal submissions between them and reference 1. Fourthly, there was no question of Rokerson, the arbitrator, having received any secret financial benefit in the case. If that objection were valid, it would mean that every party appointed arbitrator would receive a disqualifying benefit. Fifthly, there was no basis for inferring unconscious bias in the form of subconscious ill will in response to the robustness of the challenge, which was mounted on behalf of Halliburton. You can see from all this how important the tone and nature of the arbitrator's response to the challenge was in the ultimate outcome. He clearly appears to have made a fulsome apology. And this case always reminds me of what my mother used to say to me: Sue, just because you can apologise after you've done it doesn't mean you can do it in the first place. The Supreme Court may not quite have agreed with that particular line of analysis, but there we are. Does Halliburton still leave some unanswered questions? What are the practical legal consequences where arbitrators breach their duty of disclosure, but on examination after the event, the view is taken that there is no real possibility of bias? Is that a legal wrong for which there is no sanction? Might you go for a Section 68 challenge, but then face the hurdle of establishing substantial injustice? Lord Hodge suggested that non-disclosure itself could justify removal on the basis of justifiable doubts as to impartiality. He also referred to possible costs consequences. A breach of the duty might not lead to removal, but could lead to an arbitrator paying the costs of a challenge, even if unsuccessful. Another theme perhaps to think about is confidentiality and anonymity. In Halliburton, the parties were named. Popplewell J and the Court of Appeal, however, declined to name the arbitrator. In the best traditions of James Bond, he was referred to as M, but the Supreme Court did name him. His reputation and experience were relevant. What is the argument for anonymity? There are many other cases where the arbitrator is named: Hofferley, Bingham and Knowles and the like. Do we need more uniformity in practice? And touching on anonymity gives me a nice segue into Secretariat, the case where at first instance O'Farrell J heard an urgent injunction application in private because it involved 2 arbitrations. She anonymised all the parties. In the Court of Appeal, we agreed not to identify the parties to the underlying arbitrations, though in circumstances where no criticism was being made of any of those parties, we said that the adherence to secrecy was perhaps to be regretted. We did not anonymise the experts' names because without their identification, some of the points to be made were unintelligible. Lord Justice Mayles in particular said that he was doubtful that it was necessary to conceal the names of the parties to the arbitrations on the grounds of arbitral confidentiality. There had been no need to describe the issues in the arbitrations in anything other than in the most general terms, and there was nothing inherently confidential about them. So Secretariat involved another professional community, that of the world of experts. Secretariat Consulting Pte Limited, SCL, is an entity within the Secretariat Group, which, as you know, provides litigation support services and acts as delay and quantum experts in construction arbitrations. There was, in the course of the hearing before us, a lively debate triggered by Lord Justice Coulson as to whether or not delay and quantum experts are actually properly to be considered as experts at all. But that may be another topic for TECBAR on another day. There was also lively discussion about something called, or the distinction between, a testifying expert and a roving expert. Lord Justice Mayles commented that it would be wrong to seek to draw a bright line between the two. In practice and typically, save perhaps, for example, for handwriting or foreign law experts, the expert is an important resource for the litigation team. The role of a professional expert witness these days, at least, generally falls into both categories, namely a testifying expert and a roving expert. O'Farrell J found that SCL owed its client a fiduciary duty of loyalty. This meant that one of SCL's sister companies, Secretariat International UK Limited, SIUL, could not provide similar expert services to a third party, B, because B was making a claim in another arbitration against A, arising out of the same project and concerned with the same or similar subject matter. A was the developer of a large petrochemical plant and engaged B as project manager. In 2013, A let two subcontracts, Package A and Package B. Disputes arose between A and the subcontractor responsible for packages A and B. The subcontractor brought claims against A in arbitration 1. A approached SCL in March 2019 to act as its delay expert in arbitration 1. And that month, SCL signed a confidentiality agreement and carried out a conflict check across the entire Secretariat group. Engagement letters followed in May 2019. SCL confirmed to A that it had no conflict of interest in acting for A on the engagement and stated that it would, quote, maintain this position for the duration of its engagement, unquote. SCL's overriding duty to the tribunal was acknowledged. Its primary function was to assist the tribunal. In August 2019, B began arbitration 2 against A, claiming unpaid fees under the terms of its management contract. A counterclaimed for delay and failure to manage the subcontract. In October 2019, SIUL was approached by B to provide arbitration support and expert services in arbitration 2. SIUL ran a conflict check which revealed the engagement of SCL by A. SCL did not consider that to be a conflict, in spite of A's view that it was, and SIUL proceeded to act for B. Before O'Farrell J, A made a claim for breach of fiduciary duty and breach of confidence. It achieved an interim injunction from her on an urgent, without notice basis, but abandoned its claim for breach of confidence by the time of the return date. Thus, the sole issue before the judge was whether there had been a breach of fiduciary duty. O'Farrell J decided that independent experts could owe a fiduciary duty because, quote, the circumstances in which an expert is retained to provide litigation or arbitration support services could give rise to a relationship of trust and confidence. In common with counsel and solicitors, an independent expert owes duties to the court that may not align with the interests of the client. However, as with counsel and solicitors, the paramount duty owed to the court is not inconsistent with an additional duty of loyalty to the client. She reviewed the authorities, including Harmony Shipping, Jones and Caney, and meat traders. She decided that in this case, a fiduciary duty had in fact arisen because SCL was engaged not only to provide an independent expert report and also to comply with the duties set out in the CIR expert witness protocol as part of the engagement, but also to provide extensive advice and support to A throughout the arbitration proceedings. In these circumstances, a clear relationship of trust and confidence arose, she found, such as to give rise to a fiduciary duty of loyalty. This was the first time in the English jurisdiction that an expert had been found to owe a fiduciary duty to its client. O'Farrell J went on to find that where such a fiduciary duty arises, it is not limited to the individual expert concerned, but can extend to the firm or company, and may extend to the wider group, referring to Marks and Spencer and Freshfields. On the facts of the Secretariat group, she said it was unrealistic to conclude that any duty of loyalty was limited to SCL. It was owed by the whole Secretariat group. That duty had been reached, the arbitrations were concerned with the same delays, and there was a significant overlap in the issues. By contrast, the Court of Appeal disposed of the matter not by reference to the question of fiduciary, but rather by reference to contractual duties. We held that the expert's overriding duty to the court or tribunal did not mean that the expert could not in law owe a fiduciary duty of loyalty to the client. Indeed, the expert's overriding duty to the court could be said to be one of the prime reasons why the expert may indeed owe a duty of loyalty to his client. The client knows that an expert will only say in court things which represent their honest opinion. But we were reluctant to find that there was a fiduciary duty owed by the expert, unless we absolutely had to jump one way or the other in order to dispose of the appeal. This was because of the potential unseen ramifications of such a finding, owing to the legal baggage attached to the expression fiduciary duty. Fiduciary. The position was then left by us that, depending on the terms of the retainer, the relationship between a provider of litigation support services or expert services on the one hand and his or her client on the other might have one of the characteristics of a fiduciary relationship, namely a duty of loyalty. As for contract, we decided that SCL did owe a contractual duty by way of the conflicts clause in its retainer, by which it had confirmed not only that there was no conflict at the time of the agreement, but also agreed not to create any such conflict in the future. So we decided that as a matter of contractual construction, informed by the factual background, the undertaking given by SCL bound all the other companies in the Secretariat group. The scope of the conflict check extended to all of them. The companies all carried the same brand name on their email addresses, invoices, and covering letters, and acted as if their different geographical offices were part and parcel of a single organisation. Further, SCL and SIUL had common directors and common ownership. And finally, we decided that there was a conflict of interest in this case because the experts acting for A in arbitration 1 and against A for B in arbitration 2 were giving advice for and against A's position. The parameters of the advice required by A and B were closely aligned. There were obviously overlaps of parties, role, project, and subject matter. We recognise that there may well be circumstances where the same expert can act for and against the same client, for example, on different projects. Large multinational companies often engage experts on one project and see them on the other side in relation to a dispute on another project. But the overlaps in this case, in our view, amounted to a clear conflict of interest. We referred to a punchy partner quote in Hollander. It's not difficult to work out what a conflict is. You put yourself in the client's shoes and ask yourself, would you like you doing what the other client has asked you to do? If the answer is no, you've probably got a conflict. I think that's probably a bit rough and ready. I remember when I was in chambers, if I really wanted to do a piece of work but was worried about a conflict, I'd go to somebody who I knew had pretty liberal views on conflicts. And if I really didn't want to do a piece of work, I'd go and take advice from somebody who I knew took a much straighter approach, much stricter approach. So standing back and rounding up, what does all this mean? Well, as I've said, it was probably inevitable that arbitrations would sooner or later come under some scrutiny by the courts, given the rapid expansion of the arbitration industry and the prolific use of what can be a relatively small pool of experts and arbitrators. The court's interventions in these cases, I would have thought, are welcome. They bring some clarity on issues of bias and conflict that are of everyday practical importance, whilst recognising the necessary autonomy of the arbitral process. We fell short of deciding that experts owed a fiduciary duty to their clients. To extend their responsibilities that far would potentially have effects that are very wide-ranging and prescriptive in a case where it wasn't necessary to go that far. Similarly, in Halliburton, the Supreme Court decided that whether or not there was an appearance of bias would depend on the facts and circumstances of each case. Both courts were unwilling to set down a rigid approach to be applied in all future cases. The Secretariat does highlight the correct approach for courts to take to the notion of any duty of loyalty. Contrary to first instincts, perhaps, there is no conflict between the expert's duty to the court and their duty of loyalty to the client. In fact, the position is the opposite. The expert's duty to the court is precisely what drives them to provide an honest and thorough service to the client. Similarly, in Halliburton, the court's confirmation of an arbitrator's legal duty of disclosure will support the relationship between arbitrators and parties, providing confidence to parties that arbitrators will conduct themselves in accordance with contractual duties. Parties can also now perhaps be more critical of arbitrators who fail to disclose the full extent of any potential conflicts, safe in the knowledge that the arbitrator's duty of disclosure has been upheld in the Supreme Court. Arbitrators can be left in no doubt that they have a positive obligation to disclose, including where appropriate, perhaps to make reasonable inquiries, and to do so at the earliest point. It seems to me that the tide is turning towards greater disclosure in the future, which may present a challenge for a small community of arbitrators. The experts in Secretariat were, as I've said, found to hold a contractual duty of loyalty. I suspect that experts and their clients are looking carefully at the contractual terms of loyalty and confidentiality on which they are engaged or engage, and that large groups of companies providing such services are considering their internal structural arrangements and branding so as to maximise their potential properly to accept retainers without giving rise to conflicts of interest. As Lord Justice Coulson said, it is perfectly possible for a group like Secretariat, if it thought it commercially sensible to do so, to make plain that its representations as to conflict of interest and its undertakings for the future were based solely on the entity involved, and that, despite the scope of the conflict check that they had undertaken, no such representations or undertakings were given in relation to any other entity in the Secretariat group, and Lord Justice Mayles made comments to similar effect. There remain questions about the wider impact of Halliburton on the arbitration community. Whilst some may consider it business as usual, the Supreme Court's decision is likely to have a wider impact beyond Bermuda form arbitrations. As the Supreme Court noted, arbitral institutions may consider creating new rules detailing what can and cannot be disclosed. Such rules may also clarify the position in relation to the duty of confidentiality and strike a balance between disclosure and confidentiality. Arbitrators may need to improve their record-keeping processes. Some consider that the decision in Halliburton could undermine London's position as the worldwide centre for arbitration. In particular, criticism has been levied at the Supreme Court's failure to discharge the arbitrator, despite having found that he breached his duty of disclosure. However, there are precious few examples in other jurisdictions where arbitrators have been removed in similar circumstances. And I don't, as a matter of English law, consider that the duty to disclose has been undermined by the fact that the arbitrator here nevertheless survived the challenge. Arguably, the practical outcome in Halliburton can be suitably confined to its factual, specific context. As I said earlier, the English courts are openly pro-arbitration with all that that entails. These two decisions have clarified the position on arbitrators' duties of disclosure and experts' duties of loyalty in the arbitral context. And the considerations that have arisen in the arbitral context, I think, are likely to be readily applicable and carried across into the court litigation arena. They emphasise the scope of those duties and the fact that they are rooted in the contractual relationship between the litigating parties on the one hand and arbitrators and experts on the others, something which the parties are always free to determine between them, all consistent with the concept of party autonomy, which is the bedrock of the arbitral world. Thank you very much indeed. I hope that has broadly kept to the time limit. I am going to be watching the Arsenal match at 8 o'clock. We're in good time for that, Rachel. And Annalise had to go to do her kids' tea, but she, of course, was counsel at first instance in Secretariat, so she probably didn't need to hear much, if anything, of what I said.
Thank you very much. That was excellent. Ben, have you come on to say?
I've just come on to suggest that a distinguished arbitral warrior like Stuart Catchpole must have an observation or a question after a talk like that.
Well, I wonder how much Halliburton has actually made a difference to the point of arbitrage. I think the movement has been coming for many years, which requires arbitrators increasingly to disclose even tenuous potential conflicts. I mean, the obvious ones that I frequently come across are where you appear as counsel in front of an arbitrator, and then you get appointed as a co-arbitrator with the same arbitrator. And I've had a number of cases where that's come up, where the arbitrator has had to resign. So I think that there was already a body of practice prior to Halliburton that was requiring greater disclosure. And that's got to be a good thing as well, as we promote trust and confidence.
But one of the difficulties about the arbitral world is because it's all in private, is ensuring consistency is so difficult.
I agree.
You know, judicial decisions are reported, you can follow the chain through. How do you promote consistency and just ensure that the same standards are being applied as appropriate? It's much more difficult, Stuart, isn't it? I
entirely agree. And we, without pointing the finger too much, but not in the construction world, but certainly in, some might say, the shipping world, there is a very small group of very often retired judges who come from a certain background, who appear in almost all of the arbitrations. And that does give rise to concerns, I know, from certainly with Asian clients, about how much they actually appreciate, first of all, the workings of an Asian yard or Asian companies, but secondly, that many of these people have, in their practice at the bar, acted on behalf of owners and repeatedly get appointed by owners as a party-appointed arbitrators, but there aren't many alternatives. And that has given rise to lots of, and I can already see moves being made to move away from London as a result in those types of arbitrations.
I mean, that's why, in a way, I mean, one of the standout features was, you know, perhaps things would have been very different if the arbitrator in Halliburton hadn't been so very well and rightly respected.
Yes.
You know, it's, we all know, bad facts make bad law. I'm not saying the facts here were bad, whatever, but it's potentially a different ball game. And I guess so much turns on the integrity of individual arbitrators. If you are in this very small world, you're relying on top former practitioners or former judges who are just totally straight. And that's part of it. But with a long term, that is a sustainable model. You know, when the world is changing so fast and the pressures and tensions, whether it's social media or IT, I don't know, but I suspect you're right, Stuart, that I think we may be seeing more court involvement in dealing with some of these issues.
I think the really good thing about it, I may say, is that we all know the difficulties you face in making a judgment call as to whether you're going to challenge a member of a panel on the grounds of bias. Yeah. It's just is the thing you never want to do. So I think having a ruling that is clear, that makes the duty of disclosure relatively onerous on an arbitrator, has got to be a good thing, because it flushes out the potential for a conflict or potential for bias at an early stage, and also enables parties, without appearing to be ultra aggressive or trying to take tactical advantage.
Yeah, and I mean, I can see that. I think I'm guessing there'll be a lot more focus on what the contract with the arbitrator says, and whether or not you will include an express obligation to make reasonable inquiries. You know, all that sort of stuff.
Yep.
So it's tricky.
Might I ask a question insofar as the potential chilling effect that this could have in a relatively limited pool of expert arbitrators to not want to be liable for adverse costs, as Lord Hodge suggested, could be one possible sanction, and or that there could be a scramble to amend the terms of arbitral appointments to maybe give them an opportunity to
fess up?
Well, I was going to suggest evade that potential consequence by having the parties expressly take the risk that even if there is a potential conflict, if it's deemed not to be material, and in much the same way it was on the facts of Halliburton, that they might not be liable for any unsuccessful challenge thereafter.
Yeah. A good faith omission.
Yeah.
But I'm guessing you can arbitrators can get insured for all of this, and are insured for all of this. I don't know, but one way or the other, people will be thinking about this. I'm absolutely sure. I thought Lord Hodge's comments were particularly interesting. He was the one who was, I think, sort of thinking outside the box quite a lot about around the edges. That's the point about, legal breach or breach, without a sanction, all that sort of stuff is quite troubling in a way, isn't it? These are serious breaches.
Can I ask you a question about, do you think, without revealing any secrets, obviously, that your attitude to arbitration has changed from when you were at the bar to when you've become a judge, in the way you look at it and approach it?
I am seeing on the bench a far wider range of arbitration than I did at the bar. So my exposure is being broadened. So in that sense, I'm seeing it from a different perspective, because I have the benefit of brilliant, representation. I can be informed about all the different types of arbitrations and all the different practices, whereas my own arbitral experience at the bar was somewhat narrower. So I don't think fundamentally, I see things very differently, Stuart. I think obviously being at one remove helps. It's easy to see things from a point of principle as opposed to necessarily point of practice. The one thing that this has got nothing to do with your question, which I apologise for, but the one thing I really do sometimes notice is when I have advocates in front of me who have clearly been in back-to-back arbitrations for years, and this is the first time for them in court after a long period, I do find that the advocacy approach is very different, which is perhaps of interest to TECBAR, Rachel. Certainly in the Court of Appeal, you've just got to be, when I say more focused, I'm being very general here, but tight, sharp, and on it in a way that I sometimes find advocates who have perhaps been in arbitration a lot, it's just all a little bit more relaxed is probably the wrong word, but I'm not putting this well. But it's a different style of advocacy, isn't it?
Very different, and very different to where the seat of the arbitration is and the nature of your arbitrator.
Yeah.
Of course, if you're in front of civil tribunals, which I am from time to time, that's different again.
Yeah.
Because of how you end up, the importance they do or don't put on cross-examination or the like. So I think I think it's very true, and it was certainly, I was involved in the FCA test case this year. So obviously we're sort of seeing a very different sort of advocacy, because not only was it obviously in court, not arbitration, but also at sort of neck break speed, which was also something to learn quite how quickly you can do things, which is different and something to think about.
I mean, yeah, absolutely. And so the other thing that I was interested in your views on was, I think from Halliburton and Secretariat, you're getting quite a big steer, aren't you, about anonymity, or rather non-anonymity, and are the parties really just making a bit too much of a fuss about all of that? So my guess is the courts are going to be taking an approach where, unless de-anonymizing would really risk exposing granular detail, really confidential stuff arising out of the arbitrations, the courts are getting a bit fed up with saying, or just taking it on the nose that yes, everything's confidential, or it's an arbitration, so it must be A and B and anonymized. There's a bit of, I think that's also part of open justice and the general way the wind is blowing a bit. I don't know what you think about that.
Well, it certainly does, as you say, seem to be changing. But more and more, I think it's the ICC, isn't it, who asks now whether you're prepared to have any details disclosed, and your client's sort of automatic reaction is no. But as you say, we'll have to watch the space, I think. I don't know if
so.
Had a similar experience, or...
Well, I think certainly, I imagine most of the cases we do, anonymity becomes a bit moot anyway, because most of the results of the arbitrations are reported to the relevant stock exchange or financial regulator. So the actual fact of the arbitration, its outcome, and the parties to it become public knowledge within a relatively short space of any award.
So one gets the sense it's all a bit of a fig leaf, and that's then quite interesting, isn't it? Because one of the advantages of arbitration was always said to be privacy. You take that away, is it quicker? Is it cheaper? And if it's not quicker and it's not cheaper and it's not private?
I think the difference is that, and what I notice with respect to judges, is that you do benefit from having, certainly if you don't appoint people who've been on the bench for a long time, you have the benefit of having people who have direct experience of the particular industry.
Yeah.
And have actually, for example, been in a shipyard or on a site, or actually, and understand some of the practicalities.
Absolutely.
And perhaps also, dare I say, have a greater understanding of the cultural differences between clients than even judges experienced in commercial cases have.
Yep.
And that you can lose as well after time on the bench. So you don't have to travel too far in Africa to come across the relations between Chinese and African states and infrastructure. For example, a relationship that's developed over time, remarkably different cultural approaches. Now, probably those who were in practice 15 years ago didn't have that experience. And I think that's the major advantage of arbitration, that you do have that ability to get
I totally get that.
Yeah.
Well, I've been overturned, haven't I? I can't remember which one it was, where I did something very shippingly brave, and Peter Gross sort of basically was very nice about me, but said, there were very experienced shipping arbitrators who, I can't remember what it was. Yeah, involved. No, you're quite right. Of course, you're right, Stuart. Who's watched Deepwater Horizon?
Yes.
Come on, seriously, it's it's brilliant. It's brilliant. Sian, you must have watched it.
I haven't. No, God, no, I haven't.
Okay, well, it was just getting into the groove. I watched it over the weekend.
Was that broadcast TV or Netflix?
Amazon Prime.
Ah, right. Okay, I shall track it down. I don't think I get to use all these subscriptions.
Well, I think I put, support Arsenal. Yes, I do, Bill. You don't have to trust me. Yeah.
Very strong connection with Arsenal. I thought it was interesting with Halliburton that, there is a codified guide to dealing with conflicts in the IBA guidelines. And not many areas have so much guidance.
No.
and yet these challenges are raised. And I thought, even though obviously there's extra guidance now out of that decision, I thought it was a bit of a rap across the knuckles in the sense of, even here where not telling that party when you told another one seemed to be such blatant omission, it didn't get you the result that you...
Yeah, no, I agree. I mean, I wonder whether we as lawyers, at the bar, we're so, I used to be I used to see conflicts everywhere I turned.
Oh, well,
literally on a daily basis, you'd be thinking about it. So I guess what's interesting about it, and again, this is absolutely full respect to Ken, but if somebody of his caliber could overlook it, then it does tell you, and with all those guidelines that were in place, it does tell you that this was a moment in time when it sort of had to really rear its head and come to the fore as a major issue for arbitrators.
I think it's. I mean, the problem is the pool size, and I mean that business of the feeling of conflict. It's a case of, how would you feel if this party knew?
Yeah, the Hollander test. That was a senior partner of a solicitor's firm that came up with that.
I think actually you came up with it sometime years ago when I was your pupil.
I did. If you've got to ask.
Yeah, exactly. It's that feeling of, put yourself into the position of every single person who's in play.
Yeah.
How would you feel if they knew, and go through the list? And if you feel completely relaxed about all of them knowing, then there's no conflict. But if you
Rachel, I was really going to get my old chambers into trouble by telling you who I would go to if I wanted to keep the case and who I would go to if I didn't. I won't.
Probably best not.
Yeah. But there are people, creative people who will always find a way of saying, well, and then others will just look pale and go, God, absolutely not, no way, can't touch it.
Yeah. I think it'd be nice to be back able for those in chambers to be able to go back and actually ask that question without having to phone up or whatever, just walk into a room. I think
Right.
Time is 7:05, and as much as I'd love chatting, we probably ought to bring this to a close. So thank you again, Steve, for your brilliant. Thank you to all the panelists who spoke, and especially our speakers. I thought all the talks were incredibly interesting and very detailed. I've seen a couple of, I've managed to read a couple of the questions on the Q&A, and that was whether or not the slides would be made available. I understand that they will be, but we might have to email you to tell you how that's going to happen, because I'm afraid I don't know. I must also thank my CPD team, so Ben, Tom and Sebastian, thank you so much for organising this. I think you'll all agree that it's gone incredibly smoothly. This is obviously the point where I want to say, can we thank them in the normal way, but I wouldn't be able to hear anybody clapping. So take it as read, Ben, that I'm clapping very loudly. And then just finally, before I say goodbye, could I also just advertise our next event, because it's certainly nicer for speakers if they know there's people out there, even if they can't see them. And I think it's the Junior TECBAR lunchtime webinar. Ben will tell me if I've got that wrong. And it's on the 15th of April at lunchtime this time, so that hopefully we can get maximum audiences. And that's adjudication enforcement in the time of COVID, case law, virtual hearings and thoughts for the future. David Clean is giving that. And whilst I say it's a Junior TECBAR event, I don't think there's any harm in some of our older members getting brought up to speed on that issue. So with that, I'd like to say good night, and all stay safe, and hopefully see you all in person soon for our first TECBAR social event where we're in person. Thank you.